everyone. I'm sorry for the delay. I know we were just working on some audio issues. Thank you, Ms. Muff, for your help. I want to thank you all for being here today. It's really tremendous to see this packed house, every seat taken. It's a great discussion, and I think a discussion on probably, for those of you who are students and certainly those of you who are attorneys, what you know already is, and all of our faculty who are here today as well, this is probably one of the most important, if not the most important discussions and things you can think about as an attorney entering the field. And that is how to ensure that you're operating within the guidelines of ethical expectations for the profession. And that means not just what's required of you ethically, but what's expected of you. And I know the panel today is going to talk a lot about not just that expectation that you'll be above and rise above any sense of impropriety as an attorney and as a member of this profession, but also what that means and how you practically build a career in the law while ensuring that you're surrounding yourself with the support and the information you need to make ethical decisions in a mindful way. So I'm proud that this is an event of the Levin Center at Wayne Law that we are holding now just about a year after its establishment. It was established last March, and we welcome Senator Levin as our distinguished legislator in residence. Is serving now in finishing up your first year in that position and is chair of the Levin Center. We also have the chair of our faculty committee for the Levin Center, Professor Moak is here, and several other members of our faculty and advisors as well, and including, of course, Reginald Turner, who serves on our advisory committee for the Levin Center. Just real quick, the Levin Center's done a lot in the past year. We've had a panel discussion here at the law school in the fall. We've provided several congressional oversight boot camps for congressional staff members in collaboration with the Project on Government Oversight and the Lugar Center, and where members of Congress have actually gone through trainings with the Levin Center on how to conduct good oversight. And that wasn't limited just domestically. We also had a boot camp for legislative staff in the Ukraine, led by Elise Bean, our co-director, who you'll hear more from or meet later. And of course, Senator Levin co-taught a course with Professor Schenck this semester, and I'm excited to be that Senator Levin and I will be co-teaching a course. Senator Levin and I will be co-teaching a course this fall on legislation and oversight, so a seminar. So I'm excited that that'll be a part of our curriculum as well. And as some of you know, we're also we've placed 2 current law students in summer internships in Washington, D.C. Thanks again to the leadership of our co-directors, Linda and Elise, and Professor Moak and the faculty committee. I want to thank our panelists for being here, and of course Professor Henning for moderating this important discussion, and it's now my pleasure to hand things over to the Levin Center's Linda Gustitus. Linda is also an alum of the law school. She graduated in 1975, and after that served as an aide to Senator Levin in the United States Senate for the bulk of his tenure there, 24 years. He was there for 36. And in 2001, she began serving as Senator Levin's chief of staff in the Senate and served in that role for many years. So thank you, Linda, for all that you do for the Levin Center and for being here with us today.
Thank you, Dean, and I want to thank the Dean for being such a wonderful host and an advocate for the Levin Center and for really helping us bring it here to Wayne State University Law School. And it's so much fun to be back at my alma mater. I'm so proud of this institution and the way it's grown over the years since I graduated in 1975. So I was, as the Dean said, I had the privilege of working for Senator Levin in the United States Senate for 24 years. I now am the co-director of the Levin Center for the Washington staff, and Elise Bean is the other co-director, and she worked for Senator Levin for 30 years. We were both largely the staff director doing oversight work for him on the committees that he chaired or was serving as ranking minority member on. So today's forum asks you, as you prepare to enter your legal career, to think about not only being the best attorney you can be substantively, that is with respect to the law, but also to think about how you can be the best citizen you can be. To think about the decisions you will make as a lawyer in terms of the impact that your decisions will have on the larger society. Senator Levin spent much of his time in Congress challenging seemingly reputable professionals, some of the so-called best and brightest and many of the richest, who claimed that they were just doing their job and they were doing it well, when in fact doing their job resulted in devastating consequences to the larger society. Look at the MBAs in the banking field who made a fortune packaging and selling toxic mortgages to investors, actions that led to the catastrophic financial crisis of 2008, from which we are still reeling and trying to recover. Or look at the top attorneys at the Justice Department after 9/11, who approved torture based on twisted legal reasoning, torture that many argue has become one of the major recruiting tools for Al-Qaeda and ISIS. At one of Senator Levin's hearings on the collapse of Enron, Senator Levin was going through a complicated and misleading transaction with the J.P. Morgan banker and asking how J.P. Morgan could design and execute such a deceptive loan transaction. The banker who designed the transaction kept referring to the paperwork he filled out that said it was a loan and could not grasp Senator Levin's point that in the real world, the $1 billion so-called loan he packaged was not really a loan, but it was a financial trick to protect the bank, and it ended up misleading the public on the real value of Enron. Attorneys face multiple pressures, trying to do what the boss wants, what your firm wants. How do you make money for the family? How do you serve your client? How do you keep these pressures from preventing you from both seeing the larger impact of your work and acting accordingly? To start our discussion, we're going to see a 5-minute excerpt from an undercover video made by an organization called Global Witness. Global Witness is a London-based organization that investigates environmental crimes and how people use shell companies to hide and move suspect money. In this case, it used one of its staff to go to 13 different law firms in New York to ask for their help in hiding money for a fictional client, a government official from an unnamed African nation who got millions of dollars from various companies, apparently as gratuities, and who now wants to move it to the U.S., buy a house or a yacht, and hide its ownership. Only one of the 13 firms told him to get lost. The others, well, you'll see the representative examples in the video. For purposes of our discussion today, we're going to assume that the official did nothing against the law, although it's hard to imagine that there wasn't a law in the African nation prohibiting that. But illegal conduct is a straightforward ethical question. You can't do it. The question we're raising today is, what do you do when the conduct at issue is legal, but it's offensive or unethical, and you know it will do damage to the larger society? In the video, the government is helping a government official from what we can assume is a very poor country hide millions of dollars he took from private companies for facilitating his official duties. Would you be the one attorney who said no here? That's not for me? Or would you be one of the 12 who responded positively to the prospective client? We'll play the tape, and then Professor Henning will lead a discussion with the distinguished members of our panel.
You run the country.
Still do.
I love it.
Still do. I should say some lawyers run the country.
So you are some of them, 2 of them.
Yeah, a small amount. We're still members of a privileged class. Yeah.
So what does it mean you run the country? Means you...
We make the laws, and when we do so, we make them in a way that is advantageous to the lawyer. We make the laws. Some people say we select force the laws. Another way to look at it is the old adage, a good lawyer knows the law, and a great lawyer knows the judge. Now, in point of fact, I went to law school with half the judges who sit on New York State Supreme and Federal District Court in New York. This happens that way over time.
Right.
We do the lunch with members of the Bar Association. Association. Are they going to throw a case for you? No. Are they going to bend over backward, courteous to you? Yes, they are.
If his name now would appear in connection with buying some real estate here and other items, it would look at least very, very embarrassing.
Right, because presumably his salary and wherever it is would not cover the kinds of acquisitions.
For sure, that's the salary of a teacher here. And so how can you make sure that he is being able to buy property here and to live a nice life, but his name being out?
Right.
So if you're buying in New York, you would probably want a New York LLC.
This is being done
Any
undercover.
problems with setting it up? Who would
Oh,
own
understand.
this?
So
Who is-
presumably, we would set up a little bit of a series of owners to try and protect privacy as much as anything else.
Yeah.
So company A is owned by company B, which is owned jointly by company C and D, and your party owns all of, or the majority of the shares of C and D.
So we create several companies.
Yes. You'd probably be better off with a smaller bank. Because
That will be a possibility.
because the bigger banks are much more serious about
The reputation.
yes.
And there may be other banking systems that are less rigorous on this than the U.S.
What would it be?
Number of possibilities. England has gotten recently very tough on this stuff too. Usual banking havens, I think would be ones you would want to consider. We could provide a list of countries where the banking systems require less detail on ownership or source of funds.
You'd set up a Delaware corporation to own the real estate.
That's right. So it
That's
could
the
be.
same, that's the same cost.
So you don't have to,
But what would be better, in Delaware or in New York?
well, if you set it up in New York, you have an attorney general that has to review everything, and you have a state that has a big corporate tax department and everything else. You set it up in Delaware, that's where every corporation sets up. There's too many. The franchise tax is very small, and you don't get involved with big tax returns.
The same for me. My standards are higher.
But that's fair enough. It's good.
What?
Therefore, I said we have to be very frank. So
Right.
yeah.
That's not interesting.
Do you know anybody who would be able
I
to
don't
sell?
think so, and I wouldn't recommend it. Because those persons would be insulted.
Let there be lights, and I'll turn this on.
Now everybody has to wake up. I'm Peter Henning. I teach here at the law school. I have the joy of teaching professional responsibility every once in a while. And these are the kinds of issues that come up broadly in that class. And so I'd like to first have our panelists speak. I either have the easiest or hardest job. The hardest part of it being they have to speak briefly, but there's no way I'm cracking the whip. But we have our three panelists. We will begin with Senator Levin, who spent 36 years in the United States Senate, led the permanent subcommittee on investigations that looked into a number of areas related to money laundering and anonymous companies. We will also hear from Judge Nancy Edmunds, who is one of our graduates from 1976. And I guess next year we'll be celebrating her 25th year on the United States District Court for the Eastern District of Michigan. And finally, to my immediate right is Reginald Turner. He is a partner at the Clark Hill firm and was the president of the Michigan State Bar, heavily involved in both the State Bar and the American Bar Association. And indeed, it mentioned he is a good friend with one of the people portrayed in the Global Witness investigation. So let's start with the senator.
I'll tell. Peter, thank you all for coming. What you witnessed here is not particularly typical. You don't have somebody walking in an office every day, particularly where most of you are going to practice and saying, I've got hundreds of millions of dollars to buy real estate. And, you want to keep it anonymous, but you'll be faced with ethical questions, perhaps not as obvious as these ethical questions, but ethical questions all the time. Today, what you saw here is in today's headlines. This is not something abstract. U.S. News today, massive leak reveals money rings of global leaders. It's today's news. This is a firm in Panama that for I think 30 or 40 years has been creating phony corporations, shell corporations to help people hide money. Linda mentioned the Enron case. Well, their lawyer, one of the top lawyers in the country, Vincent Elkin, ended up paying $30 million in cash in settlement to avoid a trial as to what their role was in Enron. The accountants went to jail, some of them, but the lawyers didn't. There's a lot of questions. How come none of the lawyers went to jail? But they ended up paying $30 million, and this is a top firm, one of the top firms, so-called, in the United States. So these kind of ethical issues are current and they're real. There were a lot of red flags here for the lawyers that were being interviewed, secretly, by the way. I hope that was obvious to everybody. This was undercover. The camera was not known to the person who's being interviewed. But the dilemma that you face, you will face as lawyers and as young lawyers, is what do you do when somebody comes into the office, wants to be represented, and says they need something which raises red flags in your minds? What do you do? Particularly as young lawyers, what do you do? Why those flags are red will depend on a lot of circumstances, a lot of different issues. This one has to do mainly with the request to create corporation which will preserve the anonymity of the real owner of the corporation. That's what's involved here. This is a huge issue now. There's nothing wrong with forming corporations. Corporations are a totally legitimate form of enterprise. Their purpose, theoretically, is to limit liability, not to provide anonymity. But they do provide anonymity. And so there's a major effort going on now, which you as lawyers will be aware of, to require that secretaries of state, when they incorporate some entity, ask for the real owner, ask for the beneficial owner. The lawyer that you saw here that kind of sounded interested, too interested by far, in helping this crooked guy who said he represented a minister in a foreign country. This issue here was fairly obvious as to what he was doing. But the key question here is, who is the person? Who is the real client? And by the way, they never asked. The man who came in said, I represent a minister in a foreign country. So that lawyer that you saw that seemed interested never even asked, even at the end of the interview, who was your client? So if you're asked, for instance, I'm just giving this as an example, by someone coming in saying we'd like to incorporate, it's going to probably be incumbent on you, I hope, to say who's the real client. You act as an agent for somebody, but who's the real person and why? Is it for a business purpose or is it to hide money? And if it's to hide money, from whom? There are actually, theoretically, reasons that you would want not to have a lot of money disclosed publicly. For instance, you might be embarrassed by being rich or whatever. But a lot of the reasons are illegal. A lot of the purposes, the motives for trying to hide money are illegal purposes. Trying to hide money from creditors, trying to hide money from a spouse, trying to hide money for child support, trying to hide drug money. And so you need to ask questions if you have suspicions. Nobody can probably train you as to what suspicions you should have. Through your life experience, you're going to have some suspicions in cases, in most cases, hopefully not. But if you have suspicions, the one thought I would leave you with before Peter should use the hook is ask questions. You can ask questions in a way which doesn't scare your client off, by the way. I don't know if you saw the letter from the ABA here, but you don't have to ask questions which make you look like you're suspicious. After all, these are potential clients. But you can ask questions. And the purpose of the questions can be to protect the client and to protect you. Those are legitimate purposes. And particularly if you state the reason for your inquiries, if you have these red flags and suspicions. If the reason is that we want to protect you from doing anything which might be viewed as improper in some sense, if it's to protect the client, if that's the reason to ask, which is one of the reasons you should ask questions, in that case, you're not only doing the right thing by asking questions about your suspicions, but then you can do it in a way which does not turn off potential clients who may have very, very legitimate reasons for forming corporations, obviously, or even seeking anonymity. Did I go over 4 minutes?
No.
Well, I can keep going.
I believe in the Senate you can revise and extend your remarks, if I recall. Judge Edmunds, you can stay there or come up here, whatever you prefer.
It'd probably be easier to stay here.
That's
If you can't hear me, just kind of wave and then I'll go up with the microphone, but I think it's a small
We
enough.
need her on the microphone for the tape.
Oh, I'm sorry, for the video, you have to be featured front and center.
It seemed to me when I was looking over the materials for this that the reaction to the Global Witness presentation was more kind of intuitive. That is, wow, we know something's wrong here. And unfortunately, or maybe fortunately, but I think unfortunately, very few cases are that clear cut. And what I wanted to present just in the next couple of minutes is the ABA framework for thinking about these issues, because it's quite comprehensive and I think gives some good guidance to lawyers who are very unsophisticated in this area and those who have a lot more depth of knowledge. I also ran off about 20 or 30 copies of what's called the Voluntary Good Practices Guidance for Lawyers to Detect and Combat Money Laundering and Terrorist Financing. So anyone who's particularly interested in the subject, feel free to pick them up as you leave, because it does give you some pretty good guidance. One of the tensions, obviously, between detecting money laundering and the risks that go with it, and your responsibility as a lawyer, is that you're responsible for client confidentiality. You know, your client has to be able to speak to you without fear that you're gonna turn around and go to the authorities or whatever. So there is some tension that the ABA tries to address in its voluntary good guidance. And what they do is set up a structure of risk analysis. And as opposed to just creating some rules saying, for example, if you don't know the beneficial owner of the asset that you're asked to launder, then that in and of itself is enough. What they do is suggest a sliding scale of risk, and they ask you to look at risk in 3 areas. First of all, client risk, and they suggest that there are 3 steps required to be taken in basic client evaluation. 1, verify the identity of each client on a timely basis, as Senator Levin suggested. 2nd, verify the identity of the beneficial owner of the client. The purpose of identifying beneficial ownership is to ascertain who effectively controls a client. It's impractical in some instances for a lawyer to identify the beneficial owner of an asset, and in that case, that increases the risk. So you're really looking at this sliding scale of risk. Where does your transaction come out? 3rd, obtain information to understand the client's circumstances and business relative to the nature, scope, and timing of the services to be provided. So that's area of risk number 1, the client. Area of risk number 2 is the service risk. That is, what are you being asked to do? And some very high level or high risk transactions might be the buying and selling of real estate, the managing of client money, securities, or bank accounts, the organization of contributions for the creation, operation, or management of companies, and the creation, operation, or management of legal persons or arrangements, and buying and selling of business entities. The 3rd area of risk is the country or geographic risk. Obviously, something coming from an African minister who's facilitated mining leases or whatever he was supposed, mining licenses, is a lot more risky than somebody who's, putting together something in Germany or the United Kingdom or something like that. So that's another area of risk. So the Good Practices Guideline tells you how to look at all of these factors and come up with what you think the risk assessment is for a particular transaction. As a young lawyer, and I see a lot of very sophisticated older lawyers here, you're not likely as a young lawyer to have to make this evaluation on your own. But I think it's helpful to have the ABA framework to think about these issues. And with that, I'll let it go to Reggie.
Good afternoon. It's my privilege to be here with you today, and certainly a privilege to be on a panel with these 2 distinguished members of the bar. Senator Levin has been an icon for me for a very long time, and I think we all are very fortunate to have his association with Wayne State University Law School and to have him continuing to work to share his very strong ethical values with students and with the general public. Senator Levin is so highly viewed by so many that soon there will be the USS Carl Levin that will be christened shortly as a commemoration of the tremendous work that he's done on behalf of our nation during his time on the Armed Services Committee of the United States Senate. Let's give Senator Levin a round. Judge Edmunds has been someone I've looked up to since I was very early in my practice, and she just reminded us that it's been 25 years that she's been on the bench. She obviously started quite young because she was such a distinguished lawyer at such an early stage in her career that she was recognized by the president and nominated to the United States District Court for the Eastern District of Michigan and confirmed easily by the United States Senate on the basis of her. Well, I think your qualifications and integrity were the basis for your easy confirmation. And again, so it's quite a privilege to be here. You know, the most respected lawyers distinguish themselves by breathing life into the lawyer's oath with the powerful words of the oath. We pledge to respect the constitutions of our nation and our state and to practice law with civility and integrity and with concern for all of our clients, those who can pay us and even for those who cannot pay us. And so the profession is a client-centered profession in which we are tools our clients use in order to achieve goals. And clearly, with our oath to respect the Constitution and the laws of our state and our nation, we have to do our work within the law and within the ethical constraints on our profession. And so it goes without saying that a lawyer should not facilitate any violations of the law. That is a principle that I think anybody in this room could disagree with. And the question that we have to ask ourselves is whether the conduct that took place in this video on the part of James Silkenat, who is a past president of the American Bar Association and somebody I know very well, whether his conduct violated the rules of professional conduct or any law, or whether it just kind of looked bad. And I think we all would agree it looks bad, right? If he had to do that over again, knowing that it was on camera, I think he would have behaved differently. I think I can say that. I think Jim would say that himself. But did he violate the canons of ethics? And that is a question on which distinguished legal ethics scholars have disagreed. And I don't know if you've received those materials. They have not. We were provided with materials where there were very persuasive, countervailing arguments presented by ethicists as to whether or not Mr. Silkenat actually violated the rules of professional conduct. What I would say to you as students and as prospective lawyers who will be members of this profession is that one must hold the oath sacrosanct. One should ask questions, as Senator Levin pointed out. I don't think Jim made enough inquiries during the course of that conversation to give himself the confidence that this is a client with whom he should proceed. But again, I'll read a quote from one of the professors who opined on this, Professor Stephen Gillard from the New York University School of Law. He says a preliminary meeting with a prospective client is not the place to voice suspicions about the prospective client or what the client has said, or to accuse the client of violating some trust or some law. But rather, it's an initial fact-gathering, speculative conversation about what the lawyer might do if engaged to represent the client. Keep in mind, in this conversation, the lawyer has not been actually hired yet to represent the client. They're having a conversation about what if, what kind of approach would you take to the representation of my client, and the person to whom he is speaking in this conversation is another lawyer who presumably is also bound by the rules of professional conduct, and accordingly can be given at least some presumption that that person is acting within the law and the canons of ethics as well. Again, I think we all would agree that Jim probably should not have looked so eager to help this person who seems a little, who we don't know. We don't know who this person is. All we know is that he's from Africa. Well, you know, one interesting point about the rules of professional conduct is they don't prohibit bias on the basis of race, gender, sexual preference, religion, or any of the things that most of us are bound by in various areas of employment or other activities. And so I'm part of a group that is advocating for the model rules of professional responsibility to be modified in order to have an explicit prohibition on racial, ethnic, gender, sexual preference, and religious grounds. Hopefully that will come sometime in the very near future. But should we assume that because the client of the lawyer is from Africa, that the gain is ill-gotten, and accordingly that there's some additional taint to it because this is an African government official? Some would argue that presumption would be improper bias. And accordingly, I think it's up to the lawyer, upon engagement, to ask all the right questions to ensure that the client receives professional representation, but that the lawyer does not cross the line and violate the canons of ethics or any laws in the representation of that client. I'll give you one final thought to hopefully put this in perspective, and that is there's a big part of our bar that represents criminal defendants, many of whom have committed crimes, some heinous crimes. And those lawyers take on those representations and must act within the canons of ethics to represent people who've been accused of crimes, and many of whom are guilty of crimes. So our profession is not limited to representation of the righteous. It is often engaged in representation of those who have been accused of breaking laws, if not criminal laws, other statutes that regulate conduct in business or in private life. And some of those clients have actually indeed violated the law. And so it's important for the lawyer in representing those clients not to fall into the mud with the client, but to, as I started, respect the constitutions of our nation and our state, to practice law consistent with the law and with civility and integrity. Thank you.
Here's how we'll use the rest of our time, which is I will pose a question or two to the panel and then open it up to, if a couple of you have questions for them, you can address them. As far as timing goes, I do notice, as Judge Edmunds pointed out, a couple of you may be in your third decade as students. So for the students who are in here, if you have class at 1:25, if you need to leave, please feel free to leave, but there is no class that's in here at 1:25, so we can go over a little bit. And so that's how we'll play it out. We'll see how it is. And then we might want to make sure there's a little bit of time at the end, after we're done with the formal part, if you'd like to come up and speak briefly with one of the members of the panel. So with a panel this distinguished, let me tap your collective wisdom. And why don't I start with you, Judge Edmunds. You had talked about with the, young lawyers are unlikely to face the issue of, am I going to take on this client? It's going to be a partner in the law firm. So let me give you, this is what law professors love to do, let me give you a hypothetical. One of your former clerks who has just gone out into a firm calls you up and says, Judge, I read the money laundering rules like you told us to. I think the partner is taking on a client that's getting us, or has a client that's getting us into a very gray area. We're getting awfully close to the line and maybe even crossing it. This is going to be an associate in the firm, and you, as the person that lawyer clerked for, is going to look to you as a mentor. What do you tell that lawyer? What do I do?
Well, I think a lot of what you tell the lawyer is going to depend on the relationship relationship that the lawyer has with the more senior partner in the firm. I mean, some partners you get along with great and are easy to talk to, and some not so much. But I think it is incumbent on the young associate to at least make the presentation to the partner and say, you know, I've been thinking about the transaction that we're beginning to work on for Client X, and I thought that it might be a good idea if we took a look at the voluntary guidance for lawyers on money laundering. I happened to look at it, and I'm concerned that the transaction as posed raises red flags under that outline as follows, A, B, and C, you know. We don't really know the beneficial owner of the asset that we're being asked to place, or whatever the flag happens to be. I think that the associate should raise it and should put a memo to the partner and a memo to the file. So that if the partner rejects what the associate has brought to his attention or her attention, that at least they're covered. And I think that's important because those things tend to blow up, or have the potential to blow up. And what do they say? Falls downhill.
Lots of stuff. But
Lots of
yes.
stuff, lots of stuff. I just wanted to take issue with two things that Reggie said too. And that is, first of all, I think it's very different to represent a criminal client in something where, you know, the client has done wrong, they've robbed a store, they've done some sort of criminal activity. I've always thought of criminal defense as defending the system in addition to defending the particular client. I mean, that's what criminal law is all about. To me, that's quite different from money laundering, where you're taking funds that were fraudulently or illegally obtained and cleaning them up so that they go back into the system and they're not traceable back to the illegal activity. You are participating in a crime, not just defending in court for the activity of the criminal defendant. So, and the fact that the transaction occurred in Africa, I mean, that's just one of the ABA risk factors. You have to look around the world. Some places are more susceptible to crime or to fraud than others. In some countries, it doesn't have to be an African country. It could be, you know, South American or Asian or even North American. Bribery is a way of life, and that makes it a higher risk factor in evaluating the transaction, not racism.
Senator?
I have to
And then,
agree with
Mr. Turner, we'll get to,
Right.
don't worry, I just think, I'm gonna stand back. You guys go ahead.
In terms of the young lawyer, whether you raise it with your senior firm, the answer is you raise it. Clearly, if you're in trouble, you raise it. I would have slight modifications, not major. First of all, I'd probably want to sit down with that new young lawyer and say, why are you in trouble? I'd probably want to ask questions of that person and see whether or not there's a sound basis for raising with your senior lawyer. Secondly, I'm not sure I recommend you put anything in the file necessarily. They depend a lot on your conversation with your senior. I think you probably agree. You could have a conversation with the senior, you could be satisfied, and then you would have to put something in the file. I would be a little more cautious before recommending you put things in the file, but there may come a point where you do need to put things in the file. By the way, in terms of confidentiality these days, there's not a hell of a lot of it left. Even in law firms, even with clients, this company down in Panama, there was a leak of 11 million internal documents from their law firm. critically important. That's Linda and Elise, who were my staff directors of my subcommittee, just drilled into all of the staff and into me if I fail to do that. How critically important it is to study something, know as many facts as you can, and ask questions, even of your own senior in your firm. As far as coming from Africa, as the person is concerned, that's obviously irrelevant unless there's something relevant about where he comes from. It's not relevant that he's from Africa or any other place unless the fact of the location that he comes from is suspicious in some way. And in this case, there were suspicious elements, including the fact that there are no, he said, and I don't think it was on this tape, the other parts of the tape, he indicated to the lawyer that the country that he comes from has no anti-corruption rules. But the main failing of this attorney, to me, was never knowing who he was talking to. He never asked. He asked at the beginning, and the man who came allegedly from Africa, who was obviously a phony, but nonetheless pretending he was representing somebody he didn't. When he was asked, well, who is this minister in Africa, said, well, we'll get into that later. And he never got into it. And this lawyer never asked. That is a huge failure. So I think you have to be careful for the reasons that Reg mentioned about assuming that because someone comes from a certain country or is of a certain race, ethnicity, background, whatever, you cannot assume anything fairly under both our laws and under, hopefully, our values. You don't assume it, but there are situations where, because of where someone comes from, the knowledge of what goes on in that particular country is such that does lead to certain questions.
So, Mr., you can address, let's make it a family friend, not someone who's in your firm. I know how you would handle it in your firm, but if somebody asked you, we're getting into a gray area, or if you'd rather, I don't want to say respond, but add to your earlier comments, feel free, the floor is yours.
Thank you. You know, I, as you heard me say earlier, have tremendous respect for these two panelists with whom I'm seated here, and I believe that they're making all the right points. I just wanted to offer a little bit of additional perspective with respect to, you know, the day-to-day practice of law. Again, not all of our clients are going to be completely innocent of any wrongdoing, whether that's in a criminal context or in a civil context. And lawyers get involved in representation of clients who have intentionally or in some cases unintentionally violated the law. And that's particularly true with respect to corporate clients because a corporation may have a policy against certain behavior violated by one or more employees without knowledge of senior corporate management, but the corporation itself is responsible for the wrongdoing. And that is quite frequently the situation when I have clients that come to me, corporate clients that come to me, who've been sued for violating some law, whether it's an employment law on retaliation or unlawful discrimination or some financial provision. They have the right to counsel, and they have the right to get advice from counsel on how to manage the situation, which in many cases involves my firm undertaking an independent investigation, ferreting out the wrongdoing, and advising the client on how to remedy the wrongdoing in order to move forward. So again, there would be a lot less need for lawyers if everybody was really good all the time. But what's really important is for the lawyer to be good all the time. The lawyer must, and I can't overemphasize this, even though I see some issues here with respect to this sting operation and wanted to point out those issues, I am not suggesting that what I saw on that tape is something that I would want to emulate. And as I hope you heard, I think if Jim Silkenat had to do that over again, he would do it differently. And I certainly would not have handled the situation also protects your client's rights under the law.
Can I add 30 seconds, because I want to support something that Reggie said. It's very important to distinguish between clients who come to you and say, you know what, we may have done some things we shouldn't have done as a corporation. We may have done some things wrong, and we need you to help address that fact. Have we done it wrongly? And if so, what do you recommend to us in order to improve our act? That is a very important function of the lawyer. And I think Reg would agree that that's very different from when someone comes to you and says, I want to hide some money, will you help me? His example is, we've hidden some money. Did we violate the law? And if so, what do you recommend to us in order to clean up our problem? Those are very important distinctions, but he's right. A whole lot of clients coming into firms are people who not necessarily been alleged to have committed a crime, but are worried that they may have done something wrong and need your help.
Let me open it up if anyone would like to pose a question to the panel. Yes, ma'am.
Well, I'm concerned after you do a memo to the file, where it leaves you with a senior partner when you still have an abiding faith that it's wrong to be doing the activity, and your assignment continues. I mean,
I'll throw that one to Judge
you're
Edmunds.
really faced with the ethical question.
Well, I haven't been in law firm in a long time, and it's probably a better question for Reggie.
Well, or maybe the question is this, you air it out with the partner, and the partner says, yeah, we're going forward. What do you do now?
That's why you have firm ethics counsel. And that's easy for me to say, because I'm in a large law firm that can afford to have a full-time lawyer just to advise the lawyers in the firm. Not all firms have that. We have a very distinguished ethics counsel in our law firm, and when I have a question, when I think something's even close to the line, I call him up and I walk through it with him. I give him the facts, and and he will help walk through the ethical issues associated with that matter and provide advice. It's not so easy if you're a sole practitioner or in a small firm that doesn't have ethics counsel, but the State Bar of Michigan actually has a service that you can call. You can actually call the State Bar of Michigan and get on the phone with an ethics lawyer and walk that person through the issues that you have and get a response. Again, from time to time, we're going to have clients who committed wrongdoing or want to go down a path that would not be consistent, and it's very important for the lawyer to stay within the canons and protect the integrity of the profession. And I want that to be my overarching message to you today. But it's important to be also to be able to represent clients and to represent, because even clients who may have done something wrong may be entitled to representation, should be entitled to representation, unless the representation would further the wrongdoing, which I would never do.
I'd answer that question, by the way, by saying I probably would go to a second senior and maybe a third. And if I, after talking to them, talking to ethics counsel, by the way, still thought that the firm was doing something which was unethical, I'd say I'd have to ask you not to be involved in this. And the firm would then say, make their decisions to whether they want to keep you on, if it gets to that point, or whether you want to leave. But before you get to that point, there's an awful lot of things, as Reggie points out, that you can do, including go to additional members of the firm, go to ethics counsel, and then ask for to be relieved of that assignment.
Heck, you can call me, but I'll just tell you, it depends. So one last question.
Yeah. Well, I believe Reggie Turner said that the attorneys have a duty to be honest with the court. And I wanted to bring up the issue of government attorney misconduct. And that includes prosecutorial misconduct, which Judge Alex Kosinski of the Ninth Circuit has said there's an epidemic of prosecutorial misconduct. And you could Google Kamala Harris and prosecutorial misconduct, and you'll find a link
you can actually see the Ninth Circuit argument. And there are some of the judges said that part of the problem was that a lot of judges let prosecutorial misconduct go by. There's also, then there's the issue of civil attorney misconduct. There was not too long ago in a police shooting case, the civil case for the wrongful death, a case out of Chicago. This government attorney was caught withholding evidence, and then a new trial was granted. So I guess my question would be directed to Judge Edmunds. What do you think the role is of the judiciary in kind of policing the court and making sure that the officers of the court act honestly? Here's the case of Demyanyuk v. Petrovsky, United States Court of Appeals of the Sixth Circuit in 1993. It was prosecutorial misconduct. They're talking about fraud on the court. Courses dealing with fraud in the court often turn on whether the improper actions are those of the parties alone or if the attorneys in the case are involved. As an officer of the court, every attorney has a duty to be completely honest in conducting litigation. I personally would like to see the judges get more involved in making sure that attorneys are not submitting false documents or hiding evidence. And what could you say is the role of the judiciary in that respect?
Well, the first thing that I would say is that we in the Eastern District of Michigan are incredibly fortunate to have a United States Attorney in Barbara McQuaid who does everything in her power to make sure that her staff does not engage in any kind of misconduct, including the withholding of evidence or any other improper action with respect to moving the case forward. We're spoiled in the Eastern District. We're spoiled because the attorneys do their jobs and get along with each other, and Barbara sets an incredible example of the highest ethical performance that's possible. Nevertheless, there are often, or not often, occasionally I'll say, some rogue attorneys who will do the wrong thing. One of the cases that comes to mind is the first big terrorism trial that we had here in the Eastern District of Michigan, where there were guilty verdicts found, and Judge Rosen ended up vacating the verdicts, which were very, significant at the trial because of attorney misconduct. I think that the judges in our court are very sensitive to this issue and watch for it carefully. The magistrates police that issue in reviewing discovery matters as the case goes along, and any issue of attorney misconduct, whether it's as simple as an improper statement in front of a jury or the withholding of exculpatory evidence, which of course is against all of the rules of federal procedure, are carefully policed by the judges of our court. Now, is that true across the board? No, it's not. But there are good and bad judges, just like there are good and bad lawyers and good and bad people all over the place. So we do the best we can. I know it's something that I try to be sensitive to as much as possible.
Let me end this then by, you can't buy a panel as good as this. So thank you all